U.S. Supreme Court is going to hear a case on it. In Utah, 2 bills will hit the legislature this year on the subject of civil asset forfeiture. Hi, everybody. Welcome to the County Seat. I'm your host, Chad Booth. Today, we are going to talk about civil asset forfeiture, as if you are like me, knew very little about it until recently. Civil asset forfeiture is a way for law enforcement to take ill-gotten gain money from crime out of the system and hold it for a better or higher purpose. But is it constitutional? That's the question. To understand the subject of civil forfeiture a little bit better, we start with this story from Malia Stringham.
Crime doesn't pay. We've been taught since childhood that eventually criminals reap the fruits of their dishonesty. In the meantime, however, individuals on the wrong side of the law can amass enormous wealth and possessions. Once justice comes due, the government prevents criminals from keeping their ill-gotten gains through asset forfeiture, which allows law enforcement to seize material possessions or cash that resulted from those criminal activities.
Asset forfeiture is the legal ability of the government to take someone's property. Now, there's 2 types. There's criminal asset forfeiture, where they've convicted someone of a crime and then they take their, if it was a car or money or whatever was involved in the crime. That's fine. Then there's civil asset forfeiture, where they don't actually have to convict anyone of a crime. They don't even have to charge somebody with a crime. If they merely suspect you of being involved in a crime, they can still permanently take your property away from you, and that's where the problem is.
Asset forfeiture cases can be heard in both criminal and civil courts, which offer distinct advantages and disadvantages for citizens standing before a judge. The potential for abuse of this system has led state senators like Daniel Thatcher to propose bills to act as a check on civil asset forfeiture cases.
There is a perception that law enforcement just takes all your stuff when they arrest you, and that's not accurate. You can't just rob somebody's wallet. You have to be able to prove in a court of law that those monies were criminal proceeds. If you can't, then you can't take the property. It's already being returned. We hear all these horror stories. None of them are from Utah. In Utah, asset forfeiture is not being abused. However, that doesn't mean we can't raise the bar. It doesn't mean we can't do better.
Brian Green, a member of the Utah House of Representatives, believes Senator Thatcher's legislation does not go far enough.
Senator Thatcher's bill creates potentially a streamlined process for cases under $10,000 to be dismissed if there is no criminal prosecution that ensues in relation to that forfeiture. But it still requires the individual claimant or owner of property to come forward and insert themselves into a legal process that is, quite frankly, confusing to most citizens.
Not always are government laws perfect in their approach to justice and protecting people's rights. And so we use it as an example, one of many, to say the laws are not necessarily protecting justice. They're not necessarily protecting property rights.
Senator Thatcher maintains that his bill covers every base that Representative Green is looking to protect.
If the amount is less than $10,000, and if you do not flee the jurisdiction, if you are not charged within 60 days, the property is returned with no cost, no fight. If it is more than $10,000, then it follows the same process that it does now, which is why there are specific directions to the prosecutor for 2 circumstances. One is called the Hardship Exception. The second would be the innocent owner exemption.
That exemption protects those whose property was used by someone else to commit a crime. In this episode of the County Seat, we're going to get the perspective of those on the ground who know what happens when the rubber of asset forfeiture meets the road of law enforcement. For the County Seat, I'm Malia Stringham.
Correct you are, Malia. We will be right back with our guest panel here on the County Seat.
There's a little place on a Utah map where I was raised, where my heart's at, where the sagebrush grows wild and high, and the stars come out at night. Oh, there ain't nothing like being raised reservation, skiing, starvation, that Duchesne County life.
When the road takes you farther than you knew possible, when the world is more beautiful than you've ever seen, when home is more comfortable than it should be, this is when you know you're in Kane County. The perfect mix of rural and urban, culture and adventure. Glendale, Orderville, Kanab, Bigwater, small towns with more to offer than just peace and quiet. Kane County, Utah. Find the new you.
Let's be honest, you don't know much about Beaver County. Well, let me tell you about it. It's the birthplace of outlaw Butch Cassidy and inventor Philo T. Farnsworth. Some of the best skiing in Utah is at Eagle Point. You've got camping, Canyon Breeze Golf Course, Crusher and the Tushers, Beaver Territorial Courthouse, snowmobiling, renewable energy, Pioneer Car Show, Squeaky Cheese, ghost towns to explore, best water in the country, Paiute ATV trails, Old Frisco Kilns, horse racing, hunting, fishing, and it's a good place to live. Beaver County, mountains of fun. I could tell you more, but why don't you come and see it for yourself?
Planning your next conference or corporate event? The Davis Conference Center offers 70,000 square feet of flexible meeting and exhibit space, plus high-tech audio-visual services that will make your event a success. Whether you're planning a training, meeting, company retreat, wedding, or large convention, let the staff at the Davis Conference Center help you arrange your next event. Located east of I-15 in Layton, call 801-416-8888 or visit davisconferencecenter.com today.
Welcome back to the county seat. Our topic today is civil asset forfeiture. Two bills are headed to the Utah State Legislature this year to be considered. Joining us for discussion, as Malia said, on the ground, we have the Deputy County Attorney from Weber County, Christopher Crockett. Thank you for joining us.
Thank you.
And, of course, from Utah County, Sheriff Jim Tracy, a veteran to our program.
Thank you.
Thank you for joining us. I think it would probably, as I got into the research on this, and started looking at it, I'm having a hard time distinguishing clearly between criminal forfeiture and civil forfeiture. Can we just kind of take a minute to remedially explain that?
Sure. The primary difference between civil and criminal forfeiture is that in criminal forfeiture, there's actually an information filed against a criminal defendant, and included in that information is a request to seize and forfeit the property. In civil forfeiture, it's actually a separate process. It's filed by a complaint and summons. The property is named as the defendant, and then people who have an ownership interest in that can appear in that case as a claimant.
So it actually, if somebody is, and I guess this is an important part, in civil forfeiture, people who aren't necessarily involved in the crime that have a stake in the asset then are privy to the legal proceedings. Is that correct?
A prosecutor is required to serve any known claimant with a copy of the summons and complaint. And so we would serve anyone who we know has an interest. Sometimes we don't know right at the forefront who has an ownership interest, and those will come forward as the case progresses. But there's a process to allow a third party to intervene and appear in a civil forfeiture case.
And that doesn't happen in a criminal case?
In the criminal case, I haven't done many criminal forfeitures, but in the criminal case, my understanding is that once a conviction is obtained, then a third party has the opportunity to appear and make an ownership claim to assets that have been seized.
That's my understanding. So let me ask you a question, Sheriff Tracy. What is the difference between asset forfeiture and seizure at the point of arrest? So you catch you're on I-15, your deputies pull somebody over, they have a large stash of cocaine and an even larger stash of cash. Now you collect all that stuff up. Is that civil forfeiture?
No, that would be evidence processing as far as both of those items can be used as part of the criminal case. If it's not clear that there's some kind of a crime involved at the moment, but we have a reasonable suspicion or a probable cause, but we really haven't established some of the facts of the case yet, we may seize that as a temporary seizure until we understand what we're looking at in the criminal and or either the civil asset forfeiture side. Sometimes things are seized to just maintain the status quo under either or process because we're not sure where it may go as the case develops.
Okay, so if we walk through the process, then you come across ill-gotten gain, you make an arrest, or you seize the proceeds, then you make a determination as to whether this should go ahead as criminal forfeiture or civil forfeiture, and then you begin the process of determining who's to be involved in that case. Is that?
And I think it's important to understand that the county attorney makes those in the prosecution side, those decisions. We submit what we have for evidence in the case, and then they look at the issue and the language of the crime and see if they have all the elements or where they take or bifurcate that process.
Okay.
Property that's seized, a seizing agency has to provide notice of an intent, of intending to have that property seized for forfeiture, and then they refer the case to the prosecuting attorney's office to be screened. If it's not, if a civil asset forfeiture case is not filed within 75 days, by law, the state is required to return that property.
Okay, and so it's pretty much held intact during that period of time.
It is. There's many safeguards put in place under the current law to help protect an innocent person.
Okay.
Yeah, for example, currency will go into a trust account.
That's correct.
Okay. It won't be the exact dollar bills they get back with the little note on, written on it,
Sometimes maybe, but not always.
Most of the time it's just deposited into a trust account.
Okay, very good. We're going to take a quick break on the county seat. When we come back, we'll continue our conversation on civil asset forfeiture. We'll be right back on the county seat.
149 million years in the making, dinosaurs once roamed this land. Now they're found at the Dinosaur National Monument. Let's take you beyond the bones. We call it Dinosaur Land. You'll find it offers adventures and sights not seen anywhere else in the world. Come to Dinosaur Land, Vernal, Utah. You'll want to stay forever. The dinosaurs did.
There is a place where looking out means looking in, where an impression lasting only a few seconds will be imprinted on a life forever, where courage is forged and innocence rediscovered, where remembering is rewarding and forgetting unforgettable. There is a place where truth is felt and where seeing is believing. There is a place.
Welcome back to the county seat. We are in a conversation about civil asset forfeiture as opposed to criminal asset forfeiture. I think one of the areas that raises the biggest question for me is what are the advantages of doing civil asset forfeiture instead of just saying it's related to a crime? When do you decide which one to pursue?
Under civil asset forfeiture, I would say one of the advantages is how quickly a case can be resolved, especially if there is a third party besides an individual who's been accused of a crime. It helps, they're allowed to intervene in that case earlier. The case has to be heard more quickly, whereas under the criminal route, it could take a while to have that conviction obtained and then get the third parties involved.
So I'm coming up with a scenario. All right, so you pull a guy over in Utah County with the cocaine, and he's got $10,700, and 10,000 of it he can't explain. These 700 is his brother-in-law's deposit from his cookie factory that he said I'd drop off at the bank on the way. Is that the kind of thing you're talking about, where it's all impounded and then he's saying, hey, wait a minute, that $700 was supposed to pay for cookie sales?
Sure. Under a civil forfeiture, the third party would be able to assert that claim. I would be able to verify that. I would probably ask for certain documentation to show that that $700 is actually for what that purpose.
And a sample of the cookies, right?
Yes, and a sample of the cookies. But then I'm allowed to have the judge enter an order. We take care of that portion and release that portion of the funds to that individual.
But if it were criminal forfeiture, you wouldn't be able to do that.
My understanding, I'd have to refer back to the statute, is that it has to wait until a conviction is obtained to notify third parties and allow them to assert their ownership interest.
Do you ever have a situation where a civil forfeiture takes place and the evidence for the trial doesn't come together till after the 75 days, but you've exercised civil forfeiture in other words, what I'm saying is you take money in evidence, and if you can't get the conviction quick enough, that evidence has to be released, or they can petition for it to be released, and then that asset could disappear by the time you get to criminal forfeiture?
Well, it may not be released because it could be held as evidence, but if it passes 75 days under the law, a prosecutor is prohibited from seeking civil asset forfeiture, so it cannot be forfeited to the state in that manner.
From a law enforcement perspective, it doesn't seem like you should care whether things go through criminal asset forfeiture or civil asset forfeiture. Is that correct?
No, there are reasons to have it go one of either way. I mean, there are times, and there are very few, and I think the state of Utah should be noticed that it's not an abusive situation that occurs right now. But there are times when you have a situation where you stop an individual, mainly in drug cases, you find large amounts of money. You may not even find any drugs, because this money is going back as cartel proceeds to Mexico. And this happens, and occasionally with our task forces, happens quite a bit. You have an individual who now says he doesn't know who that money belongs to. He doesn't know where he got it. He doesn't know where it's going. So what have you got? You've got a large amount of cash, which the individual is not now claiming. To put it into found property is an issue with law enforcement, because then it prohibits it from going back in and being allowed through the CCJJ adjudication process to go back in and be requested to help in the continued fight on drugs. If it's found property, then it goes into the school's trust system, and that money is lost to law enforcement. So there are times when you have people who deny the ownership, and yet you have substantial amounts of property or money, and you don't know where they're going to. That's the perfect time to put in a civil asset forfeiture and go through that proceeding.
Okay, so this is a good point, and I think it needs some clarification. You just said that when those assets are seized, there's a general perception of people that say, you know, you seize the Ferrari and $20,000 in cash, and it becomes the new narco squad patrol car, and you buy a new wardrobe for the guys that are on the narco squad. I'm using old phrases, but that's not exactly how that works.
No. Anything that's seized also goes through a process that the state has already put into law, and that it goes into a fund under the criminal justice juvenile justice group, the CCJJ, and then we have to petition back to have that released to us if they agree that there's a good cause to do so, and then bring it back into law enforcement. Otherwise, if it's found property, then it goes into the state school system. But we can't just seize that property, and it would be evidence if there's evidence of a crime. But if it's there and nobody claims ownership, and yet we still haven't found a crime, then that's the issue. Where did that money come from? Whose is it? And how do we determine where it should go if it's, quote, abandoned?
Well, and obviously, if somebody is going to finish the link of a crime, they're probably not going to come forward to say, that's my money.
That's correct.
Why?
That's correct.
Well, that used to represent $1 million worth of cocaine. So I presume that
at one point, our reasonable suspicion is that it is ill-gotten gain, that it came through a crime. It's not normal that a large amount of cash is not known where it came from by the individual carrying it, and he doesn't claim ownership of it. And like I said, those are the small or the few times that it occurs when civil asset forfeiture is appropriate, because there is no owner being claimed, no one coming forward.
So, you know, Libertas, as they have come out against this, makes it sound like constitutional rights are being abused, and we have no right to do that unless something's adjudicated in court of law. But this, you make this sound very reasonable. What's your take on that?
Well, I mean, there's a specific statutory process that has been followed for a number of years, and there's a level of proof that has to be made in order to seize assets. It's highly governed by statute. There's reporting requirements. It's been recognized as constitutional both on federal and state levels. But I think the notion that, you know, we need to be ever vigilant of protecting individuals' rights is well taken, that we can always look for ways to make sure that we are following the law and there are no abuses, always ways to improve.
So Senator Thatcher in the story made reference to the fact that don't confuse his attempt to improve things with the fact that there is a problem in Utah. You feel we are fairly well governed as far as how we handle civil asset forfeiture?
At my level, I do. I think we have those safeguards in place by statute and past practice. But like I said, can we make sure that we have a law that ensures that there aren't abuses and that we can set the bar higher, as Senator Thatcher said? Yes. But I hope we don't get into an issue where we try to fix it till it's broke and eliminate a valuable tool.
So you set the bar too high, the guy with the pole vault can't get over it.
That's right.
Okay. Very good. We are going to take a quick break here on the County Seat. We'll come back with our closing thoughts in a minute and wrap up this topic on civil asset forfeiture. Stay with us here on the County Seat.
What would you do with an extra day in Utah Valley? Explore the Wasatch Mountains? Snap a family photo at Bridal Veil Falls? Cool off on Utah Lake or the Provo River? No matter what you're searching for, you can find it in Utah Valley. Bring everyone together.
The Utah Farm Bureau has always been there to fight for the needs of its members, with discount programs on items ranging from vehicles and ATVs to health and wellness. The membership fees aren't big, but the results are. We've been around since 1916, and we're not leaving anytime soon. Utah Farm Bureau. We work for those who work to feed the world.
Color. It's something that can be seen. But have you ever wanted to reach out and touch it? Experience it. In San Juan County, Utah, color comes to life like nowhere else on earth. Color can be more than an abstract. Color can be your gateway to a new world. Visit San Juan County and explore the past, present, and future in a way that you've only dreamed of. San Juan County. Color your experience.
All local products have a story of magical places, real people, and delicious recipes spanning generations. So go ahead and discover flavors you've never tasted and friends you never knew you had. Utah's own Discover Local Food.
Welcome back to the County Seat. We've been talking today about civil asset forfeiture. Councilor Crockett, that has a nice ring to it.
Yeah.
I would like to, in the break you kind of hit on something I think needs some clarification. When money is forfeited through civil asset forfeiture to CCJJ, it's not just all sitting there waiting for the sheriff to come back and say, hey, I can use that.
Right.
Where does that money go?
Well, it's governed by statute. Once that money is forfeited, it's turned over to the CCJJ. That goes into a fund that's used for training purposes for law enforcement to combat narcotics use to help reduce that. It's also used for victim reparations. It's used for drug court. So it's used to fund a number of things. If law enforcement wants to petition to use some of those funds, they'll make an application through CCJJ, but it is governed by the state. And there are also reporting requirements that seizing agencies and prosecutors have to turn over information to the CCJJ every year, and that's made public. So there is oversight.
And that information goes back also to the legislature, and they look at that and review as to what effect their laws have had on public safety or any of those programs.
So if you petition to get money back, you say you want a new task force or some piece of equipment that'll help you in interdiction of narcotics, you've got to justify that that it was well spent?
That's correct. Well, that it will be well spent. And then we have to send in our documentation on where it was spent. So from start to finish, it's well tracked, and from start to finish, within the statute, it is maintained in an effort to not have a victim become an innocent victim, become a victim of the process.
In your experience, either one of you, have you ever kind of looked at, because that burden of proof isn't quite as high in a civil case, going, yeah, I'm wondering if have you ever had doubts?
I have, for cases that I've read that have come through some of our periodicals out of state, where clearly it wasn't within the realm of justice or even morally right, where this has occurred. And I think that's why there's so much concern nationally about this, that even, we understand that possibly federally they're looking at this issue of civil asset forfeiture.
And as a prosecutor, I have ethical obligations to make sure that, I'm filing cases that have a solid legal basis. There's adequate facts to be able to get the result that I want. But if I have a case that's referred to me to be screened and I have questions about it, my decision is not to file the case. I decline to file it and return the property.
Excellent. Gentlemen, thank you so much for taking the time to join us. Thank you for allowing us into your home each week to talk about these important issues of local governance. Remember, local government is where your life happens. Be involved, be part of the situation. Share this with your friends. You can watch it again on social media, and we'll see you next week on the County Seat. Thank you. If you like this broadcast of the County Seat and would like to see more, why don't you subscribe to our YouTube channel? Or you can check out our website or follow us on social media. If you'd like to watch a broadcast of the County Seat, we're on every week, Saturday nights at 11, Sunday mornings at 8:30 on ABC4, Good for Utah.